Contract to buy and sell real estate, video 3. We will be going over disclosures, inspection, and due diligence. Section 10, property disclosures, inspection, indemnity, insurability, due diligence, buyer disclosure, and source of water. 10.1, seller's property disclosure deadline. By signing this document, the seller is agreeing to deliver to the buyer the most current version of the seller's property disclosure form that has been completed by the seller to the seller's actual knowledge. If they do not want to provide one of these, you need to put an NA for non-applicable in the dates and deadline section in section 3. If there is a date provided in there and the seller then signs this document, that is them agreeing to provide this. It is an optional document that the seller does not have to provide unless they sign this document agreeing to provide it. Section 10.2, inspection objection deadline. The buyer acknowledges that the seller is conveying the property in as-is condition unless with the inspection the buyer has objections. If these objections cannot be resolved, the contract can be terminated. If the buyer does have objections after the inspection has been done, they must provide the seller with written notice on or by the objection deadline. With the inspection objection, they can either choose to terminate the contract or let the seller know of any unsatisfactory conditions and see if the seller will correct them. After that, you have the inspection resolution deadline. If the buyer has any objections and wishes the seller to complete them or resolve them, they must do so by the inspection resolution deadline, or at least say that they are going to complete the corrections that need to be done. 10.4. Basically, 10.4 is stating that the buyer takes responsibility for any damages that are done to the property if they are letting one of their agents in, either themselves, their actual agents, any inspectors or appraisers that go in. If an inspector goes in and breaks the garage door, it is the buyer's responsibility to have that fixed. .5 talks about property insurance and finding out if they can find satisfactory insurance for the property on or before the insurance deadline. If they do not, they do have the right to terminate. Due diligence documents would be anything such as any leases or other agreements such as easements that are part of the property. These need to be provided to the buyer by the due diligence deadline. The buyer then has a right to review all of these documents, and if they do have any objections, they must provide them by the objection deadline. If they are not, the buyer does have the right to terminate. .8, buyer disclosure. The buyer represents that the buyer does or does not need to sell and close a property to complete this transaction. This would be if they need to sell their own home or something like that before they can actually purchase this property. Next is 10.9, and that is the source of potable water. And this is where the seller would provide their property disclosure and source of water addendum. And also if there is a well permit, they would need that number here as well. And this is saying whether or not the buyer has received them or has not. Carbon monoxide alarms must be in every residential property within 15 feet of all bedrooms and all gas appliances. Lead-based paint disclosure. If the property was built or had a building permit issued prior to January 1st of 1978, the contract will be void unless the lead-based paint disclosure form is signed by the seller and the seller receives the completed form prior to the time that the contract is signed. So the seller must provide this form to the buyers before signing this contract or the contract is void. Methamphetamines, 10.12. If the seller knows that meth has ever been manufactured, processed, cooked, disposed of, used, or stored on the property, the seller is required to disclose this fact. The only time the seller is not required to disclose this if it has been property remediated up to state standards, and then it is not considered a meth property anymore. Buyer does have the right to terminate if they receive notice that this was a meth property and it has not been remediated to the standards established by the State Board of Health. Section 11, Colorado Foreclosure and Protection Act. This basically states that if the seller is going into foreclosure and this is a short sale, that the seller has the ability to terminate the contract if the selling price is less than what the bank has agreed on for the short sale price.